noted that the lawyers have arrived, so the meter will be running, so we might just press on. Yeah. So we've got a legal update from the guys at Bartier Perry. So we've got David and Mark here again today, so thanks very much, guys, for coming along. Our honorary legal representation for the society. So I'm not 100% sure on what... Oh yeah, by my slide, Gary. Yeah, so David's given us going to give us a general legal update on where we're at in the industry. So for those of you who don't know, David is a partner of Bartier Perry in their building and construction team, been practicing in commercial law, commercial dispute resolution for over 30 years. So clearly started law at a very young age. David advises in all matters of building and construction issues, from the front-end contract preparation, negotiation, risk allocation, administration of the contract during the project, and the back-end dispute resolution and contract termination, which is where some of us come in. So I'd like you to welcome David Creais. Yeah. Yeah, I'll run straight in.
Thank you. Set myself up here. Okay. So we can see if I'm going right. Oh, no, gone the wrong way. There we go. Here we are. Okay, I'll just set this up. So, good afternoon, gentlemen, and Joe. So I'm here with my colleague Mark Glynn, who's up the back and works in our building and construction section. So, if you've got any questions afterwards, both Mark and myself happy to answer them. So, what are we talking about today? So, just a couple of things that are happening around, and in particular. You notice that says signs of a contractor in financial trouble. I think on your flyers it talks about sins of a contractor. Probably not too far off, I suppose. What you can, when you know they're in trouble, what you can do about it. Security of payment has raised its head again, and so there've been some very recent, as of the 21st of October, changes to that. And then Mark actually flicked me through an email late last week about the new building practitioners bill that's been introduced. So I'll have a quick chat about that as well. See how we go from time after that. Okay. So identifying contractors in trouble. Well, as we know, construction industry is plagued by contractors going in and out of bankruptcy, in and out of insolvency, phoenixes and so on, but that gives you an idea of just how disproportionate it is. 23% of insolvencies compared to what the construction industry generally contributes to the economy. So it's clearly a prevalent thing, and often you as building consultants will be called in when there are issues that arise because a builder is running out of money. Sometimes it's because the principal isn't paying him or her or it. Other times, and most often, it's because maybe they've overcommitted, overquoted or underquoted, haven't got up on the variations that they've wanted to get up on in order to supplement the lump sum. So it's a real problem for principals. So what are the signs? Well, first one there, the attitude of subcontractors. If you go out on site and there's a lot of grumpy subcontractors, they're moaning about their invoices not getting paid, well, that's an obvious sign. And indeed, it's tied to the second bullet point there, the numbers on site. If you find that the numbers of contractors on site, number of workers on site is starting to drop, then that's probably an indication that the subbies aren't getting paid, or the builder can't pay the subbies, so he's slowing it down. Maybe he's waiting for a payment on another site, but another clear indication. If all of a sudden job's been going gangbusters and then it starts to slow, that's an indication. Of course, if your contractor's running out of money, there are only a couple of places to get it from. If the bank's not giving it to him, he's got to get it from the principals. So you'll find that the progress claims start being well overstated, and they'll start having to get knocked back. But the fact that you're getting overstated progress claims and variations that aren't variations, that's another indication that your contractor's in trouble. And then, again, kind of a segue from that, adjudication applications by subcontractors. So, as a principal, you may not know about an adjudication application by a subcontractor to the head contractor, but there is a facility under the Act for a subcontractor, when they make an adjudication application, to notify the principal so that the principal doesn't disburse funds to the head contractor and then they don't find their way down to the subby. So if all of a sudden as your principal starts getting notification of adjudication applications by subcontractors, another sign that there's a problem with your contractor. So what do you do? What do you do about it? We would advise that you get in and do something about it early. Don't let it run its course. Oh, is he going to fall over? Is he not going to fall over? I wouldn't be advising my client, if I'm acting for the principal, oh, look, let's just wait and see. Let's just keep a close eye on it. You really need to be going in there early to try and sort things out. Whether sorting things out means coming to some agreement with the contractor, whether for accelerated payments or something, or trying to terminate the contractor then and there, because they're the stats. Now these stats are taken from a sample, so you'll see the source there is Cordamenta. Cordamenta Real Estate did a review of about 80, I think, of their cases of difficulties where they'd had to take over. They're an insolvency firm where they'd had to take over construction projects, and they looked at, I think, medium density and both commercial and residential of projects under 30 million. And of their sample, the average was that if the builder failed on site, the cost increase was going to be at least 20%, and the increase in time, which is obviously the big one, is 16 months. So the earlier you get in, the better. Now, what do you do when you get in? Or even if you haven't terminated the builder yet, if you can get on site and start looking at what can be done to try and avoid a total disaster. Defective works. If the builder's in trouble, then he's going to be taking shortcuts. So you want to get in and look hard for defective works. The guys on the project, Dale?
How do you get into those sites? I mean, when a builder is in control of a site and you identify there's some difficulties, we've got one particular one on now where there's a frame stage, a lot of defects happening, and the builders just go, well, we don't think there's a problem. How do we get into that site? Well, how does the principal get in that site legally to look at those problems?
Well, you've got a couple of ways to do it. If there's a clause in the contract that allows regular inspections, then you can utilise that clause. If the builder's making progress claims, then you can say, well, I need to come in and inspect the work, and at the same time as you're inspecting the work for the progress claim, have a look for defects. You'll be looking for that anyway, because as you know, you can deduct the cost of rectifying defects from the amount of the progress claim. And then thirdly, negotiation. If the builder is in dire straits, then the principal directly or through you can say to the builder, look, understand there might be some issues here and there might be a couple of defaults by the builder. Let's try and sort it out. We want to come on site and do a bit of an inspection, see where you're up to, see what solutions we can find, and in the course of doing that, keep your eye open for defects.
Can the builder prohibit legally the owner getting a building consultant on site when he wants to inspect his progress claims? He wants to have special help from a consultant?
No, if there's an inspection to be done for the purpose of progress claim, then the principal can do it through a principal's representative. If it's an agent, if it's a contractor of the principal, that's fine. They can't really object to whoever the principal is getting to go and do the progress claim inspection. You're an agent of the principal, same thing.
The other thing that they can insist on your insurances as soon as you walk onto that site to indemnify the builder in case of an accident. And oftentimes, when we've been asked to go into a site, they ask us for public liability insurance to make sure that if an accident occurs, that they're not held responsible.
Well, that's a classic tactic. So you've got to make sure your insurances are in place. Remembering, of course, that the builder most often is required to insure the site for public liability. So you're probably covered under his insurance anyway.
Yeah, but they want to pass it on.
Well, of course they do. Yeah. Okay, ransom subcontractors. So these are the guys who perhaps haven't been paid, are essential to the job. Remembering, if you're going to sack the builder, then are you going to sack the subbies as well? Are you going to get a whole new crew in? That creates difficulties. So you want to see if you as much continuity as possible. But if you've got subbies who haven't been paid, they might be sitting there saying, well, we're not doing any more unless we get paid, when your principal may already have paid the head contractor and he just hasn't passed it on. So at an early time, it's a good idea to identify which of these subcontractors is likely to be an issue, again, so you can plan for it and work something out with them. Project documentation. Last thing you want to do is sack the builder and then have no documents and be relying on going back to council and finding the DA. I mean, you're not going to get all your working drawings and shop drawings and stuff from there. So you want to identify at an early stage who's got the drawings, who's got the project documentation. Might be an architect, might be a project manager, but whoever's got it, you want to make sure that you get a hold of it. Very important. Similarly, securing the certification chain. So if you need a waterproofing certificate, etc., fire certificate, you want to make sure that you're able to secure that. So you need to find out either has that certificate been given to the builder and not been passed on as yet, or if it hasn't been given, make sure you get on side with that party so that they will continue on site even if the builder is sacked. Key personnel, same thing. So they might be the builder's employees, they might be his project manager, might be supervisor, but people who are intimately connected with the project. You want to see if you can secure them to keep going even if the builder goes off site. Otherwise, you're starting from scratch and it's going to increase those costs. Remember, average an extra 20% costs and that time. If you don't do these kinds of things, then that's going to blow out your time as well. And lastly, an independent assessment. And that's especially where you guys come in, because if you talk to the people who, and the experience tells us that if you talk to the guys who are already engaged on the project, they are going to underestimate both the time for completion and the cost to completion. So you need an independent assessment. Now, whether you guys do it or you get a QS to do it, but that's very important when your principal is contemplating, am I going to sack this guy, am I not going to, what's the timing on it? So they're the important things in terms of what to do if the builder's showing the signs of insolvency. So next topic, Security of Payment Act. Now, so I'm sure we're all certainly aware of, if not familiar with, the Security of Payment Act. It's relevant to you guys as consultants and obviously to your principals, and it's relevant whether or not you're advising the contractor or a principal. So these changes apply to construction contracts entered into after the 21st of October 2019, so after last week, yeah. So it's important when an invoice comes in, or indeed if you're issuing an invoice and you're claiming under the Act, to work out when the contract was entered into. And perhaps the third bullet point there is the one that's going to be the most tricky, and that is where it's back to the future. Back in April 2009, I think it was, they decided in their wisdom that payment claims under the Act no longer actually had to state that they were payment claims under the Act. And so any old invoice, as long as it identifies the project and the work done and the amount claimed, counted as a payment claim. Now they've decided, well, actually, we were probably had the right idea in the first place, and so now to be a payment claim under the Act, it has to say, this is a payment claim under the Building and Construction Industry Security of Payment Act 1999, or words to that effect. John?
Should we include that on our fee agreement, that all claims made are under the Security of Payment Act?
I think you absolutely should. Whether they are or they aren't, you should definitely have it at the bottom of your invoices. Yep.
Oh, and on your fee agreement too?
Well, if it's on your fee agreement, that's not going to help, because just a fee agreement is just that. It's a fee agreement. It's not an actual claim. The Act only applies once you issue an invoice and make a claim. So that's the place to have it. And if you put on your fee agreement, all invoices are made under the Act, that won't comply, because it's actually got to be on the invoice that's issued.
David, does that only apply to us if we're invoicing a builder or a head contractor?
No, you can invoice a principal. Absolutely, you can invoice a principal. If you're doing construction, what's within the definition of construction work, which includes consultancy in relation to the construction of a building, then and you're doing it for the principal, then yes, you can utilise the Act.
The head contractor, but probably not mum and dad, or
No, you can't. Sorry, you can't do it to mum and dad. Yes, that's the big exception. So, although it was one of the recommendations was that the Act apply to residential dwellings where the owner, where the principal is going to live, they didn't take out that exemption. But that doesn't mean it doesn't apply to residential work and residential dwellings. It's only excluded if the actual owner is going to live in the dwelling. So if you're working for a company, so if a company is the owner, even if the directors of the company are going to live in the property, doesn't matter. The company doesn't live in the property and the Act applies. So,
The owner-builder, is that in that situation as what you've just described? Like the Act would apply to an owner-builder?
well, probably not, because to be an owner-builder, you've got to be building the house for yourself to get an owner-builder permit. So in that case, they would be living in it, and so the Act doesn't apply.
What about for an owner's corporation, for like Australia units?
An owner's corporation is exactly that. It's a body corporate, so it can't live in the strata units. So absolutely, the Act applies. Yep.
Yeah, David, I rarely do it for builders, but when I have, they often pushed it out so that it's 30 days from the end of the month that you've submitted the invoice. Would that,
The payment.
even if you put it in the second of the month,
Yep.
they'll say it's 30 days from the end of the month.
That will depend on what your terms are with the builder. So if your terms say payment within 7 days, then that applies. And as you see, if there's nothing in there, then it's now 20 business days. Yeah.
David, does that mean...
That's head contractor to a subcontractor. So you're not you're not really a subcontractor. So you're contracting directly with the builder if you're working for the builder. So it's from the time in which your payment claim becomes due.
Does that mean if you on your invoice you put payment is due in 7 days,
Mm-hmm.
and you've got the other clause in there about the state payment of claim?
Mm-hmm.
Does that stand? The 7 days or back to the 20 days?
It's Mark. It's the earlier of. It's the earlier of. This is the outside. Yeah.
And 20 business days.
Yeah.
But David, isn't the 20 business days if you want to dispute the claim? It's not actually about your payment terms.
No. So there are different time limits under the Act. So if you issue a payment claim, then the respondent, the principal or the builder, has 10 business days in which to put on his or her or its payment schedule. If they put on a payment schedule within that time, well then, if you want to dispute that payment schedule, if it's less than your claim, then you've got 10 business days in which to apply for an adjudication application, apply for adjudication. This is talking about payment. So this is about the time when you're entitled to be paid. So for example, if you don't have terms, so if you don't have 7-day terms and you issue a payment claim and there is no payment schedule, then the other party, the respondent, is obliged to pay you within, was it 30 business days for a head contractor? So, yeah, so...
Would we fall under the definition of a subcontractor if we don't have a sort of, unless it's a prepaid cost agreement sort of thing, we charge closer to a cost agreement of a solicitor than to the cost agreement of a subcontractor?
No, well, you wouldn't be a subcontractor because you're not supplying work for the head contractor which is then going to be passed on. You're just supplying direct work. You're a consultant to the builder. If it's the builder, obviously, if it's the principal, you're not a subcontractor. It's a direct relationship. Yep.
Acting as superintendent, we were getting claims from a builder, and he was producing his invoice straight out of whatever I think it was,
Mm-hmm.
and it's had the payment date exactly the same as the issue date. And
Yep.
each time I'd send back saying it's unfair and reasonable to expect payment on the same date. So if that's their terms of payment, for example, but we're not committed to that zero turnaround time frame on which is what they've been stipulating on their invoice. But it's if I come back within our 10 days of dispute that and say that it's unfair and reasonable, at least 7 to 14 days is more a reasonable time as opposed to zero time from the date of invoice to the due date. Is that fair enough? Or does that mean I'm still at the fault if I go 2 days out?
Short answer is it depends on the contract between the builder and your client, and which will ordinarily stipulate the terms. And if the terms in that contract are you've got to pay immediately on receipt of the invoice, then yes, that you have to pay immediately on receipt of the invoice. Okay, well, the invoice isn't in accordance with the contract, and it's the contract that prevails. But if you're putting in a payment schedule, then you're not disputing the time within which payment has to be made after you receive a valid invoice. What you're disputing is whether the amount of the invoice is correct, whether that work hasn't been done or there's defective work, etc., etc. That's what you're generally.
And at the 10-day point, if there is no payment schedule, then the amount is assumed agreed.
Then it's deemed to be payable, and the builder can go off and register that, get a judgment, and there's no defence to it, except that the claim itself was invalid for some reason because it didn't state that it was made under the Act, for example, or there was no I'll come to reference dates, but or it was too soon or whatever, but you can't dispute it on the basis that there's defective work or that it's been overcharged or things like that if you don't put a payment schedule in. 3 other significant amendments. So I was just talking about reference dates. So reference dates is the date on which you're allowed to put a payment claim in, and this has caused a great deal of litigation as to what the reference date was under the contract, whether there'd been 2 reference dates within a month, whether there'd been 2 payment claims in relation to 1 reference date. So they've tried to simplify it and say that you can make monthly payment claims. So your contract can still specify you have to make a claim by the 25th of the month, but if there's nothing in there about that, you can make monthly payment claims. And again, similarly to that, there was a couple of judgments that said once the contract has been terminated, unless the contract contemplates that payment claims can be made after the contract's terminated, you can't make any more. Well, there is now a statutory right to serve a payment claim on the date of termination, or with a reference date on or after the date of termination. So just because your principal terminates the contract doesn't mean that payment claims won't still come and have to be dealt with. And lastly, setting aside an adjudicator's determination. So there's been a payment claim, probably there's been a schedule, builder doesn't like it, applies for adjudication, the adjudicator makes a determination, one or the other side doesn't like it and says it ought to be set aside because he hasn't taken into account my submissions on this particular aspect. Doesn't matter if the adjudicator gets it wrong. The adjudicator can get it wrong. But he has to get it wrong on the right basis, if you like. So if there are 3 issues and you put in submissions on all 3 issues, and for whatever reason the adjudicator ignores your submissions on one of those issues but does on the other 2, then you can claim and finds against you, then you can say, well, that's not fair, that's not natural justice. He was obliged to look at all the issues, he ignored my submissions, therefore his adjudication determination ought to be set aside. And under the common law of administrative law, if there was one flaw in the determination, the whole thing went, even if the rest of the determination was okay. Well, the legislation now says it is within the power of the Supreme Court to just set aside a determination in part. So you might still be stuck with the balance of that determination. So that's the Security of Payment Act and the 2 things that I had prepared. Now, Mark, as I said, asked me about the Building Practitioners Act and what it all means. So the building practice, it's only a bill at the moment, so it hasn't come into force. When it does come into force, so this is on the back of the Shergold-Weir report on the Opal crisis, the one down at Rosebery, all those things. So they're trying to regulate buildings even more than they're regulated at the moment. And they're doing that in part by requiring what they call building practitioners and design practitioners to sign compliance certificates that say that the design is in accordance with the BCA or that the building's been constructed in accordance with the BCA. And in order to give one of those certificates, you have to be registered as either a design practitioner or as a building practitioner. So the question from Mark was, if you're a consultant, you're out there and you do some drawings, you might do a scope of works for building work to be done, does that make you either a design practitioner or a building practitioner, more likely a design practitioner, I think, unless you are supervising or coordinating that building work, in which case you might be a building practitioner. Do you then have to be registered, and do you have to give one of these certificates? Well, as Mark also put in his email to me, the devil, of course, is in the detail, and we don't actually have the detail as yet. Now, I'll just dial up the legislation. Okay, so what's building work? Building work is work involved in coordinating or supervising. One or more of the following: A, the construction of a building of a class prescribed by the regulations for the purposes of this definition, the making of alterations or additions to a building of that class, or the repair, renovation, decoration or protective treatment of a building of that class. We don't have the regulations yet, so we don't know what the class of building is. So whether it's going to be all classes restricted to a class of buildings, we don't know. But if, when the regulations come out, you are coordinating or supervising either construction or alterations or additions or repair, etc., then that is building work for the purposes of the Act. So then what is a regulated design? So a regulated design is a design of a class prescribed by the regulations that is prepared for building work, and without limiting that description, could include a design for a building element, which is basically your classic fire safety, waterproofing, structural element, or a performance solution for a building work or a building element. Now again, we don't have the classes prescribed as yet because we don't have the regulations. So it's possible, it's quite possible that you might have to become registered as either a building practitioner or a design practitioner. A building practitioner is a person who contracts to do building work, and a design practitioner, when I find it, is a person who's registered as a design practitioner under the Act, and a design practitioner is a person who prepares regulated designs. So really, it's a bit of watch this space. Now that bill has been issued for public comment. Unfortunately, submissions closed, I think, on the 16th of October, having been issued on the 2nd of October, so they didn't give anybody much time. So we really will have to await the regulations and what changes might be made to the bill. But if the class of buildings is your regular dwellings, commercial buildings, then if you're supervising or coordinating work, then you're a building practitioner. And if you are doing a design within the class prescribed, now we don't know what that class is, but if it does come within that class, then on the face of it, you're a design practitioner and you'll be required to register and required to issue a compliance certificate. That's on what we know so far, but again, devil's in the detail. So that's about where we are in terms of a legal roundup at the moment. I do usually finish my presentations by leaving you something a little less serious. Given that we're getting close to, well, the shops have already got all the Christmas stuff out. It's all happening. We know it's happening. So I thought I'd give you something for Christmas morning when the kids or the grandkids are around, the classic dad joke, which involves a bit of a Star Wars theme. So we've got Darth Vader and he's got Luke Skywalker in front of him, and it's coming close to Christmas, and Darth Vader says to Skywalker, "I know what you are getting for Christmas." And Skywalker says, No, you can't know. "I know what you are getting for Christmas." Skywalker says, No, you don't know what I'm getting for Christmas. "I know what you are getting for Christmas." But how could you know what I'm getting for Christmas?" "I have felt your presence."